Please be seated. Next case on the docket is Patel v. Solomon. Counsel for the appellant.
Good morning, Your Honors. I'm Frank Rayner, appearing on behalf of the defendant appellant, Chimanbhai Patel. This case deals with the transfer of venue, or a request for a transfer of venue by the appellant based on 47.122 Florida statutes, essentially on the basis for the convenience of witnesses in this matter. The record is undisputed in this matter that the material defense witnesses are all located here in Leon County. They will comprise sheriff's deputies, prosecutors, eyewitnesses, that the physical evidence is held here in Leon County in an evidence locker with the Leon County Sheriff's Office. So that is clearly established in the record. The question that really was presented below was presented by Judge Reynolds, really, on his own, was the Bassett case, and whether or not that case would require him to have a judicial notice of the fact that there's a superhighway between Leon County and Gaston County that would be convenient for witnesses to travel up to Gaston County. Now, this is a unique case. There's no other decision anywhere else that says that because there's highways between two counties, that would be the basis for the convenience of witnesses or to deny a motion for the convenience of witnesses under 47.122.
But I know your dissatisfaction with the language in Bassett, and I've read Judge Reynolds' order, but I don't really read Bassett as establishing a per se test that says if you've got an adjacent, if the issue is venue between County A and County B and there are adjacent counties and there's a highway between them, I don't think it's, I think it's something you can consider, but it's not a per se test. And I think that's the way the third DCA read Bassett.
Well, the third DCA understood it could have been read two ways.
Right.
That it's not a per se test, but if it's considered a per se test, they rejected it.
Right.
Is what they did. Judge Reynolds, in his opinion, basically said he felt that was a standing stare decisis basis of judicial notice that he had to recognize and that he had to implement in this particular proceeding.
But it was a fact that he could consider.
It is the fact that he considered, that this case existed. Now, the question then we deal with is its judicial notice. This is a 30-year-old case, long before the adoption of the evidence code and the implementation of the various procedures and processes that are utilized for judicial notice. One, that you have to have notice ahead of time, an opportunity to contradict it, which was not given in this proceeding. It was brought up sui sponte by the judge at the proceeding. And number two, it's a 30-year-old fact. The superhighway, I don't imagine any of you judges, I imagine a few of you judges here have driven the superhighway. You know that in 30 years there's been a lot of change and different development, et cetera, along the highway. And so had this fact been one that wanted to be utilized for this proceeding, it should have been noticed, and then contrary evidence should have been allowed in the proceeding. But I would still tell you anyway that regardless, this decision has been criticized. It is a decision that I think that this court should re-examine at this point and not be utilizing or not having it uniquely applied to Gaston County. It's really a very unique decision in that it essentially only applies to Gaston County for this state. The proper analysis is for the court is to look at the trilogy of cases of U.V. Crockett, the Brown and Williamson case, and the Morrell versus Lytle cases. If you look at that trilogy of cases from this DCA, I think the answer is quite clear that venue should have been transferred here for the convenience of witnesses. The Morrell v. Lytle case is the most recent one, 2005.
The standard of review is fairly restrictive. It's abuse of discretion, and the definition of abuse of discretion, it seems to me, creates a fairly high barrier for reversal in a situation where a trial court is looking at various factors, the witnesses, the parties, et cetera. Couldn't we affirm here on this record, even if we think the trial court misread Bassett?
Oh, yes, absolutely, because the evidence is clear. I mean, it's undisputed that the evidence is clear that all the material witnesses are in Leon County. The event occurred in Leon County. The evidence, the physical evidence is maintained here in Leon County. There's not, Other than the plaintiff and the defendant, there is no other witnesses that would come to the trial.
The witnesses, I'm sorry.
Go ahead.
Even if the witnesses are Leon County, the fact that that Gaston County is adjacent to Leon County necessarily means that perhaps it's easier for them to get to Gaston County. I mean, if you live on a certain side of town, it's easier to get to Gaston County than it is to get to the Leon County courthouse.
Well, see,
So that they are here.
But we're
doesn't
falling back into the
necessarily mean it's
Bassett
gonna be-
analysis. That's where we're going. And
Well, what about the witnesses that lived in Liberty County, and the argument that, you know, Gadsden County is, I guess, equidistant? I mean, you've got people that have to travel from Leon, people that are going to have to travel from Liberty County. It's closer to Gadsden County. So,
well, the witnesses, first of all, for the plaintiff were never identified by affidavit, and that's another point we've made, that there's never been any countervailing affidavits supplied by the plaintiff here to contradict this. So we don't have any evidence from the plaintiff that these witnesses are in Liberty County or wherever else. But the fact is that if you look at the Morrell, I don't know how you could not reverse after looking at the Morrell versus Lytle case. That case makes it clear that if the material witnesses are located in the county where the event occurred, this was an automobile accident case, if you just substitute automobile accident for malicious prosecution, it's virtually the same. And it says that decision of this court held it was an abuse of discretion. And that's pretty common actually throughout all the circuits, that when there is an event that occurs, such as an automobile accident or a tort event, and all the material witnesses are located in the county where the event occurs, that it is abuse of discretion to not transfer venue to that county for the convenience of those witnesses. The material witnesses that are not parties to the case that will be called to before the court, before the tribunal. I mean, the purpose of this statute is basically to ensure that there's live testimony and to encourage that there can be live testimony at the proceeding. And that is what we need.
You're down to about 3 minutes.
Okay. I asked for 2 minutes for rebuttal.
Okay.
Overall, Your Honors, I ask that you recognize that we have a little anomaly here in the law, a 30-year-old anomaly for Gaston County, that we correct that Judge Reynolds does not feel he has to be constrained continuously in the future by this decision, and to apply the standard trilogy of cases that would normally be applied to this analysis, being you, Brown and Williamson, and Morrell. Thank you, and I ask for reversal.
May it please the Court. My name is Frank Myers. I represent Mr. Solomon. And even though the trial court didn't abuse its discretion in this particular case, apparently I did in my brief by bringing out Kenny to you, I now recognize that Hugh v. Crockett and the Brown and Williamson case were the correct analysis to apply to this rather than Kenny. However, having said that, there are 3 factors to consider, as Your Honors are well aware. And if the appellant gets you to focus on just one of them, the convenience of the witnesses, the appellant hopes to convince you that that's enough to find an abuse of discretion. So let me address that head on. First of all, it's not inconvenient for these witnesses to go to Gaston County. The courthouse is literally 24 miles from here. Rule 1330 of the federal rules, the Florida Rules of Civil Procedure says that if a witness is more than 100 miles away from the courthouse, he's deemed to be unavailable for trial. So the court the law has already recognized a 100-mile barrier as being something to contend with for a witness, and these witnesses couldn't be more than about 24 miles away. So even by that legal analysis, you can see that this is not inconvenient for witnesses that have been identified. Now, counsel is focused on, he says, all material witnesses except for the parties. The parties in a malicious prosecution case are the most important witnesses that will be called. That was recognized by the trial court, and in his last paragraph, paragraph 3 of his order, he said that in the interest of justice, this dispute should be resolved in the county in which both parties reside. Now, how can the appellant come in here and look you in the eyes and say, the appellant, don't want to be tried in my own county? I mean, that makes sense that these 2 citizens of Gaston County have it resolved by Gaston County residents. Those are the people who are deciding how their county should be done, how the people should treat each other. That's why we have a jury system for people that peers of the community to look at these parties and say, this is good, this is bad, this is wrong, this is what we did. And don't be misled by the fact that the occurrence took place in Leon County. You have the address there. What is it? The 7500 block of Bluntstown Highway, which is almost in Gaston County, or almost in Liberty County, but it's near the western edge of Leon County. It's almost halfway between here and the Gaston County Courthouse. So as Judge Clark had pointed out, is it really that inconvenient for the witnesses if Mr. Patel is at his shop at Charlie's Meat Market and drives over to Gaston County, he has almost the same distance to come to the Gaston County courthouse as he does to the Leon County courthouse. And that emphasizes what Judge Clark just brought out is it really that inconvenient? It's not. It's not inconvenient for these material witnesses to travel to Gaston County, and in some ways, it's more convenient. They don't have to deal with the parking in downtown Tallahassee. They don't have to park with trying to get in and out of the Leon County courthouse. If you've been to the Gaston County courthouse, if you've seen it, you know that there's free parking all around it. There's plenty of parking, and it's easier to get in and out of that courthouse. That's convenient for the witnesses.
But counsel, the situation here is, it would appear that Judge Reynolds believed he was constrained by the Bassett case to basically find that he couldn't change venue because under Bassett, the counties were adjacent and there was a superhighway connecting the two. He didn't, in his order, make an analysis weighing the convenience of the witnesses and the convenience of the parties, and so he didn't go through that process. Should we send it back to have him do that? How do we act as a trier of fact, and do the weighing?
Well, you as an appellate court sitting in an abusive discretion review of what Judge Reynolds did can look at it and say, well, he came to the right conclusion. He didn't abuse his discretion. He may have reached it a different way than we did, but we could reach the same conclusion very easily, that all of these witnesses are not inconvenienced by going to Gaston County. Now, he had analyzed more than what an appellant would lead you to believe, because they say that all of the material witnesses were in Leon County, except for the parties. They say that the only fact the judge considered was the superhighway argument from that case. That's not true. Again, he has statements in his order that says other things that he was considering. But Your Honor may also be led to believe that simply the gut reaction of Judge Reynolds is it's really not that inconvenient for people to come from Leon County. Even there's a case out there that says it's a superhighway. I mean, his mind want to go right to that case because it's really not inconvenient to travel over there. So, no, I don't think a court has any obligation, and nor would it serve any real purpose of justice to send it back to a trial court judge and say, okay, you got it right, and we just want to see your analysis of all the witness conveniences, when we can sit here and look at the record and we can tell that Leon County witnesses can drive from the western edge of Leon County and get to Gaston County just as fast as they can get to the courthouse and get in the courtroom in Tallahassee. So the witness convenience is the most important factor for Your Honors to consider. It's not the only factor. The parties also reside in Gaston County. That's a pretty important factor here in a malicious prosecution. The appellant wants to draw in these auto accident cases about venue, auto accident venue cases. Distinctly different. In fact, the courts recognize as being slightly different. And here's why. When you're doing an automobile accident case and the person has an accident on I-75 near Gainesville, for example, there are all kinds of witnesses that flock to that accident. There's the tow truck driver, there's the ambulance runner, there's the law enforcement officer. There's all these witnesses that by nature of an automobile accident draw in the local community. That doesn't happen in a malicious prosecution case. You don't have that flurry of activity around it. Appellant will argue that, well, you have the police officers that show up. True. They show up for the arrest. The arrest that led to my client being in jail for a year for something he didn't do. And as the record reflects, the testimony against my client was this man had the silhouette of a black man similar to the guy who robbed me. That was the testimony. That's why my client was acquitted. The malicious prosecution is about the witnesses that we will call that are drawn into the malicious prosecution part. That is my client and his client, appellant. Those are the parties that are drawn in by this malicious prosecution. Not like an automobile accident where you have a flurry of witnesses coming. So, Your Honors, there's a huge distinction between Morrell, I believe, is the auto accident case that the appellant draws your attention to, and all those auto accident cases that seem to say that if it's the convenience of the witness, by gosh, you should find an abuse of discretion. Last, I'm down to 3 minutes, the last thing. should I have filed any affidavits from anybody? And Judge Berger pointed out, well, the court found that there's some hint of witnesses out in Bristol County, which is actually farther west. And fair enough, but the point is that we have the appellant admitting in his motion to transfer venue and in his affidavit that the plaintiff and the defendant were residents of the same county, i.e. the county where we filed suit. If that's true, and if this is a malicious prosecution case where it's about mostly what the appellant was thinking and how he came about trying to find my client as being the bad guy, that under that scenario, the Gaston County venue is probably and should be the best venue for this particular case. So it's not just about the convenience of witnesses. Don't be focused on that. Focus on the whole Hugh versus Crockett analysis. The interest of justice calls for these parties to be, this dispute to be resolved in the same county where both parties resolve. It's convenient for the parties to go to court in their own county. And yes, it's not so inconvenient for the witnesses to travel from Leon County to Gaston County. The trial court came to you clothed with a presumption of correctness. You should give that discretion to this particular court unless you find a clear abuse of discretion. And there is no clear abuse of discretion here. The gut reaction of Judge Reynolds is, these guys live in Gaston County, there's witnesses in Leon County, but that's not so inconvenient for Gaston County. In fact, there's even a case out there that says it's not inconvenient for witnesses to come from Leon County. I therefore deny your request to change venue to Leon County. So for those reasons, Judge, I see that no other questions are coming. I'm going to go ahead and stop and let counsel proceed. Thank you for your time.
Thank you, counsel.
It's always different doing appellate practice because you want to stand up and say, I object. But basically, we had a lot of facts that weren't in this record presented to you and material. The facts that are in this record are that the material defense witnesses are located in Leon County. The physical evidence is located in Leon County. The prosecutor, who's in the courthouse, 2 flights above the courtroom where this case would be tried in Leon County, is in Leon County. Those are the simple facts. Judge Berger, I guess you could appreciate this. How would you feel that you had a decision in your district that said St. Augustine and Jacksonville are basically right next to each other, so either one is good enough for venue for witnesses, and it's convenient for witnesses to drive back and forth between those two? This is the only county in all of Florida that is subject to this decision that says that we find it's ipso facto a judicial noticed fact that Leon County and Gaston County are convenient to travel to each other. It's the only county in the whole state of Florida. It's an aberration. It's asked that you be fixed. Judge Reynolds recognized it as an aberration. He's a good judge. He recognized the decisions that affect his county, and he felt constrained by that. He took the stare decisis judicial notice of the Bassett decision, and he essentially was based his ruling on that. I ask that you reconsider this decision, that you relieve Gaston County of this unique 30-year-old decision, and recognize that Florida has come a long way in the last 30 years with respect to roads and travel, and that the convenience of the witnesses in this instance, who are all in Leon County, be recognized and implemented. Thank you.
Thank you, counsel. Thank you both.